Good afternoon and welcome. My name is Dr. Philip Phillips and I'm the Associate Dean of the University Honors College, and it is my pleasure to welcome everyone to our Fall 2019 Honors Lecture Series on suffrage. This has been a very successful lecture series and a very well-attended lecture series. I'm pleased to see all of you who are in the class and those of you who are visiting today. At this time, I would like to invite Dr. Mary Evans to come and introduce our speaker. Dr. Evans is a resident honors faculty member in our very own building. She's also a research associate professor of history, and she directs our American Democracy Project. She is the person we can thank for such a wonderful lineup of speakers this year. Dr. Evans.
Good afternoon, everyone. I'm here to introduce our speaker today, who is Dr. Pippa Holloway. I believe that's short for Philippa, is it? Dr. Holloway is a professor of history here at MTSU. She received her undergraduate degree from the University of North Carolina at Chapel Hill and her master's from the University of North Carolina at Greensboro. Her PhD is from the Ohio State University. Since coming to MTSU back in 1999, she's taught graduate classes in 19th century history, Southern history, the history of mass incarceration, and LGBTQ history. She also teaches U.S. History Survey as part of the general education program here at MTSU. Professor Holloway's research focuses on legal and political culture. She's the author of Living in Infamy, which is up on the screen, Felon Disfranchisement and the History of American Citizenship, published a few years ago by Oxford University Press. That was funded in part by a very prestigious Soros Justice Fellowship, which she was awarded and was the recipient of. She's also author of Sexuality, Politics, and Social Control in Virginia from 1920 to 1945 through the University of North Carolina Press, which won the Rose Prize from the Southern Association of Women Historians. And she's editor of Other Souths, Diversity and Difference in the U.S. South from the Reconstruction to the Present through the University of Georgia. Her most recent article, Testimonial Incapacity in Criminal Defendants in the South, is part of her current research on the history of the right to testify in court. She was president of MTSU's Faculty Senate just last year and is currently the president statewide of Tennessee's University Faculty Senates for all universities across the state. They held their annual convention at MTSU just last spring. She's also a member of the Committee on College and University Governance for AAUP, the American Association of University Professors, and she's here today to speak to us in the context of our discussion of suffrage on felon disfranchisement in America. Please help me welcome Dr. Pippa Holloway.
Thanks for that warm welcome, and it's good to be here. I'm looking forward to talking with you guys about my research and then answering questions about it. I often title this talk Felon Disfranchisement, Past, Present, and Future, but it actually starts with the present, then we'll talk about the past and my historical research on the topic, and then we'll move into the future in terms of where public policy is going. So let's start with the present, felon disfranchisement in the U.S. today. So what we're talking about here, most basically, is losing the right to vote because of a criminal conviction. In most cases here, a felony conviction. You'll hear me say disfranchisement, although people also say disenfranchisement. These are essentially synonyms, or they are synonyms. In the past, people used the term disfranchisement without the N in there. And so since I'm a historian and I like talking about the past, I use the term of art in the 19th century rather than what seems to be sort of more common in the 20th. You can use either one today. So today, 6.1 million Americans can't vote because of a felony conviction. And this is a number that's increased pretty dramatically over the last several decades. And you can see from 1976, we were well below 1 million. I'm sorry, well below 2 million. And in present, the most present data, current data I have on that map, on that graph, up to over 6 million people. So dramatic increase in the number of people who've lost the right to vote due to a felony conviction. And this is largely because of a significant increase in the number of people with felony convictions in the past 30 or so years. You can see a graph here of the U.S. state and federal prison populations, and you see a pretty big jump there, beginning in the 1980s and continuing up to the present, although it's ticking down a little bit right now We can talk about that later if you want. So who loses the right to vote due to a criminal conviction? In 2 states, nobody does. In 2 states, you can vote even while you're incarcerated. They have prison voting in Maine and Vermont. Most common, or more common, is being disfranchised while you're in prison. While you're incarcerated, in most states, whether it's a felony or even a misdemeanor conviction, meaning you can be in prison or jail, wherever you're locked up, you lose the right to vote. California is recently experimenting with prison voting for misdemeanors, but that's another story. We can talk about that later. Prison and parole for 3 states, prison, parole, and probation for 18 states, and then prison, parole, probation, and post-sentence in 11 states, including Tennessee. So Tennessee is one of a handful of states in which you lose the right to vote permanently, unless you get a restoration process we'll talk about in a minute, if you are convicted of a felony. Which means that 77% of disfranchised voters are people living in the community, not behind bars. So there's many people in our society today that have lost the right to vote due to a prior felony conviction. Regional patterns. So take a look at this map here, or this graph here, of top 10 states with the highest rates of felony disfranchisement. You see that in Florida, 10.4% of the population has lost the right to vote due to a felony conviction. Mississippi at 8.3%, Kentucky, Virginia. These are all states with well over 5, in many cases approaching 10% of the population, the voting age population, unable to vote because of this. And you see Tennessee there. We are the, 6th highest in the country. Does anyone notice a regional pattern here? Okay, well, if you haven't noticed a regional pattern from there, perhaps you'll notice on the map here, which is the short story here is this is more common in the South, right? Southern states are more likely to have lifelong felon disfranchisement, and Southern states are more likely to disfranchise significant parts of the population. You can see here the dark red are states where 10% or more, or approaching 10% of the population loses the right to vote for a prior felony conviction. And you can see Tennessee is in that darker area. Racial patterns. In addition, these laws tend to affect African Americans disproportionately. 1 in 13 black voters nationally can't vote because of a prior felony conviction, compared to 1 in 56 non-black voters. And in some states, these are really astounding numbers. So 2.2 million African Americans, or 7.7% of all black adults, are disfranchised, compared to 1.8% of the non-African American population. In 3 states, Florida, Kentucky, Tennessee, and Virginia, that's 4, isn't it? In 4 states, more than 1 in 5 African Americans is disfranchised. So you can see there in Tennessee, 21% of adult African Americans can't vote due to a prior felony conviction. That's a huge percentage of the electorate. Florida, the reason I had that messy math of 3 versus 4 is that Florida law changed recently, and it's kind of a moving target. We'll talk more specifically about Florida at the end of today's talk. So why does this matter? The main reason it matters is that, well, there's a number of reasons it matters. First of all, it matters if you've lost the right to vote, right? If you can't participate in the electoral process because of something you did maybe 10, 20, even 30 years ago, it's going to matter to you personally. It also has an impact on elections, though. And one of the things you might have noticed from that list of some of the states that have the highest rates of felon disfranchisement are some of the most purple states, the states in which in statewide elections, Republicans and Democrats are battling it out very closely. And 2 of those purple states are Virginia and Florida. And if you've paid much attention to elections in the past couple of years or decades even, you know that often national elections, if you remember the 2000 election, the national election of the United States hinged on the electoral result in Florida, which came down to 234, was it, votes? And so if you've got 9% of the voting age population disfranchised in the state, and the presidential election hinges on 500-something votes, these start to matter pretty quickly. Virginia has also been historically a pretty close state, although it's tilting bluer now, particularly because of the partisan alignment of African Americans, right? Since African Americans are more likely to vote Democrat, if you disfranchise 20-something% of the black population in a state where elections are close, you're talking about some serious impact on outcomes. All right, let's drill down into Tennessee for a few minutes, since that's where we are and where we're most likely to be personally affected or have members of our family affected with these laws. You see here, Tennessee disfranchises 7.1% of the total population due to a prior conviction. What is the law in Tennessee? So in Tennessee, everybody who's, first of all, if you're incarcerated, you can't vote following a conviction. So people that are in prison and in jail can't vote. Ex-felons are also disfranchised during probation and parole. So you get out, you're on probation or parole, you still can't vote. You also, once you're done with probation and parole, you also have to have paid all of your fines, all your court costs, all your restitution, and child support in order to be eligible for a rights restoration. Now, if you've had any experience or know anything about this, you know that fines, court costs, etc., can be over $10,000, $15,000. So you're out of prison, you're trying to get a job, and you owe $15,000, and you can't vote until you've gotten all that paid off, let alone child support, which in Tennessee accrues while you're incarcerated. You can't pay it off, so you get out of prison and you owe potentially lots of money in child support. You still can't vote until you're square on all of that. Once you finally have done all that, then you can fill out an application. So once you qualify, how do you get your voting rights restored in Tennessee? It is complicated. How complicated is it? First of all, you have to get a certificate of restoration form, which you can get on the internet. You have to take that form, print it out, and get it signed by your probation or parole officer or a criminal court clerk in the relevant case or court in 3 different places to justify or to certify 3 different things. For every felony conviction that has a separate docket or case number, you have to get a different form, another form, and get it signed off. Then you have to bring that signed form to your county board of elections. Then your county board of elections sends it to the state. They send it back to the county. The county sends it back to you. Then you can come back and fill out another form to register to vote. This does not apply if you're convicted of murder, rape, treason, or electoral fraud. In those cases, you need to apply for restoration in court. How complicated is it? 3, if you were convicted of these crimes, you cannot use the regular form. After July 1st, 1986, between July 1st, 1996 and June 30th, 2006, I'm not going to read all this to you. Hopefully you're getting the sense that this is slightly insane, right? For these crimes, in these categories, you still have the right to vote if you can show that at the time of your conviction, the judge did not render you infamous, if your conviction was reversed on appeal or expunged, or if you received a full pardon, or if you have your voting rights restored. So there's that. Finally, good news, if you're convicted between January 15, 1973 and May 17, 1981, because all persons convicted in that time period can vote. Also, prior to January 15, 1973, you can vote unless you are convicted of one of those crimes: abusing a female child, arson and felonious burning, bigamy, bribery, larceny, horse stealing, destroying a will. But you'll notice that this weird list of crimes does not include murder or assault. So if you were convicted of murder or assault, you can vote. But if you're convicted of horse stealing prior to January 15, 1973, you can. Okay. One more thing. This is actually kind of breaking news. When I was researching this talk, I went to the Secretary of State's website, and there's a new line on there. It says right here, if your conviction has been expunged, you may answer no when asked if you have a felony conviction on the voter registration form. That appears nowhere in law and statute. I haven't checked the Attorney General's opinions. It just shows up on the website. So I emailed the American Civil Liberties Union, where they have a lawyer who works on this, and I was like, giving a talk at MTSU, do you know anything about this new line on the Secretary of State's website? She's like, we have no idea. So that's probably true, but what if it's wrong and you fill out the form and now you could be accused of voter fraud? So I emailed her twice. She's like, I don't know, I'm checking. So I don't know. Apparently this is true, but I personally wouldn't risk my liberty on whether or not, if my conviction has been expunged, I can just say, no, I've never had one. Who knows? Are you confused yet? All this is so complicated that if you go down to your election office and ask how to do it, they'll probably tell you the wrong answer because nobody actually understands these laws at all. How well is this working? Well, it depends on what you mean by working. Very, very few people in Tennessee are able to complete this insane process that I've just very briefly described for you. In 2012, for example, 921 people managed to do that. The biggest year was in 2008. In 2008, there was a huge statewide effort. The presidential election was coming on. Bunches of lawyers had workshops and clinics across the state, and they managed to get 2,400 people to get their rights restored. And this is out of about 160,000 eligible people. So what I'm telling you here is this complicated process is almost impossible for any reasonable person to achieve. And really no more than a few hundred people manage to do it every year. All right, so that's the present. Now I'm going to talk about the past. And this is my contribution to our collective knowledge about the topic. I wrote a book which published in 2013. in which I researched the history of these laws, specifically in the United States, and I'm going to share the results of some of my research with you here today. Although I did not research the bit about ancient and early modern Europe. This is from secondary sources. But just briefly, these were not laws that originate in the United States. These are laws that had existed pretty much since the beginning of democracies. If you sort of think about it, ever since there was the idea that you could be a citizen and in which citizens had certain rights to participate in things like elections, there was also a deal where if you really screwed up, you would lose some of those rights and privileges. So the exclusions of the rights of citizenship are as old as the rights of citizenship. In ancient Greece and Rome, this could happen. You could lose your right to participate in elections if you were able to vote. Or this is true in English common law, continental European law. So this was pretty common across the world where there were elections that you could lose that right. But it was very rare. And in most of those places, you would lose the right to vote for a serious crime. Those were also crimes that were punishable by death. So losing the right to vote was a fairly minor consideration if you were also about to get executed. So very rare, these are rare crimes, the most serious crimes, and very often crimes that were punishable by death. So before the Civil War in the United States, my research shows that these laws were much more common in southern than northern states. So in order to do this, I went through all of the constitutions from all of these states, and they changed pretty often. Most states had an initial constitution. They changed them in the 1820s and 30s. They often change them again in the 1850s. They're changed either during or after the Civil War, and then right in like 1868. So there's like usually a bunch of constitutions you have to read through. I also went through statutes because sometimes election laws are governed in statutes as well as constitutions. And after a lot of research, I discovered that these laws, as I say there, were much more common in southern than northern states before the Civil War. They did exist in northern states and in midwestern states. I don't want to give those states a pass, but they were generally weaker in those states. Maybe it was just a few crimes like treason or things like that, forgery, perjury, things like that. Also in northern states, they were more likely to be debated when they were passed. So like the legislature will talk about it, or the Constitutional Convention will say, should we take the right to vote away for people for a serious crime? And they would argue about it, and they would be back and forth, and sometimes it would pass, and sometimes it wouldn't. But in the South, these things are the law. They're common in every southern state, and I found no evidence that there was pushback, debate, or dissent about them. And one of the reasons for this, and this is super, super complicated, but it's the sort of intellectual, theoretical underpinning of my book. I argue that this is due to the idea of infamy in the South and the connection between being incarcerated and being enslaved. Enslaved people and incarcerated people had the same legal status. Both were cast out, marked, and degraded in the eyes of the law in the state. So this gave disfranchisement for crime a stronger hold on legal culture in the South, both before and after 1865. Kind of what I'm saying is the South had the system of people who were enslaved. These were people who were obviously humans, but had no rights as citizens. They were not seen as citizens at all. Because they were enslaved, but because of their bondage, slavery was seen as a kind of captivity. You were sort of held, captured, unfree, in the same way that being a prisoner was being a kind of bondage. You were forced to work, you weren't free, you were held. In both cases, you were beaten, you were subject to abuse, you had no rights. And what I argue is the fact that the South had this population of African Americans that were in this degraded legal position, that's the word they used back then, degraded. So that made the idea of taking away the rights of prisoners kind of a natural extension. These ideas kind of cross-pollinated. So another thing my research demonstrates is that after 1865, southern states expanded their laws disfranchising for crimes. So here we are. The Civil War has just ended, right? We're about to get we've gotten the 13th Amendment. We'll talk about that down the line. We've got the 14th Amendment about to pass. African Americans are going to be citizens of the United States, and there's an assumption that citizenship is going to come with, for men at least, the right to vote. And I found that in the immediate aftermath of the Civil War, in fact, in the elections, the first elections in which newly freed African Americans are able to vote, southern states expanded their laws disfranchising for crimes. So in the first election after the war in which newly freed African Americans can vote is in 1867. And I come across the North Carolina whipping campaign of 1866. Now, you're not supposed to have long texty slides, but we've got to have one long texty slide for this one. I'll read it to you. In 1866, a group of white Democrats in North Carolina had an idea. They undertook a campaign of mass whippings of African American men to disfranchise them. An outraged U.S. Army officer witnessing this wrote to his superiors in Washington to explain the situation. White former rebels, he wrote, conspired to seize Negroes, procure convictions for petty offenses punishable at the whipping post, and thus disqualify them forever from voting. In one county, he had heard reports that whites had already, quote, whipped over 60 men, and by next spring they would have disqualified about all of them. This is due to the fact that in North Carolina, individuals whipped as a punishment for petty crime lost the right to vote. Many whites celebrated how the whipping campaign enabled them to, quote, head off Congress from making the Negroes voters. One legislator stated, we're licking them in our part of the state, and if we keep on, we can lick them all by next year and none of them can vote. So if you're a historian, that's sort of like finding a smoking gun in the primary sources. And it's also, I mean, I just want to take a second and recognize the cruelty and horror of a statement like that, right? You've just been freed from slavery. You've just been given a promise. You're about to be given a promise of participation in the American project through voting. And what do? They go around the area and just grab people and whip them because of this crazy law that if you've been punished for a crime, then you lose the right to vote. So it doesn't matter that if you've actually committed the crime or not. And this is 1866, and this is the racist South, and we don't really have courts that are functioning very well right then. So they just grab people, they whip them, and they say, bang, you can't vote anymore because you've been punished for crime. And they do this as an intentional project that they celebrate the victory of. They say, this is the answer, right? The stupid Civil War has happened, people get to vote now, and we don't want that, so all we gotta do is we have to whip people, and we can cancel out their citizenship rights. That's powerful and incredibly disturbing stuff. And this happens across the South. The North Carolina example is the starkest example I find of it, although there's evidence of it in many other states. Now, other disfranchising techniques soon follow, which I'm sure you're familiar with. Literacy tests, the poll tax, the grandfather clause, which kind of gives you a pass on these other tests. I'm hoping you're familiar with what those are. But my point here is that the first thing out the gates, the first strategy to disfranchise African Americans in the first election after the Civil War isn't literacy tests and poll taxes, it's violence, intimidation, and whippings in order to disfranchise. After that, I turn to the 1870s and I find another interesting regional pattern, which is in the 1870s, many southern states begin to disfranchise for petty theft. What we mean by petty is small. So just so you understand here, there was a consensus prior to the Civil War that if you stole something big, if you committed felony larceny, you stole something worth more than $50 or something, you might lose the right to vote. But what's going to happen in southern states in the 1870s is they're going to lower the bar. They're going to say you can lose the right to vote for stealing anything. And they're going to use this in order to target African Americans, again, sort of like the whipping campaign. We're going to cook up false accusations that are very difficult to challenge, and we're going to use that to systematically deny African Americans the right to vote. And the way I discovered this is that once again, I went through every constitution and every statute of all the southern states, all the ex-Confederate states, and then I also went through Attorney General's opinions, I went through Supreme Court decisions, and it happens differently in every state. Some states do it in the Constitution, some states do it in statute. In some states you have an Attorney General finding that larceny means misdemeanor larceny as well as felony larceny. There's different ways that different states do it, but every state, one way or another, lowers the bar. So you lose the right to vote if you steal just the smallest object. So one of the classic examples is the election in Florida in 1880. In which African American men are disfranchised for things like theft of a gold button, theft of a case of oranges, theft of a hog, theft of 6 fish worth 12 cents. Any of those things, you were accused of it, you couldn't defend yourself. There's not, these are biased court systems that are not going to bring justice, and you'd lose the right to vote. And people at the time acknowledged the electoral and racial implications of this. It was a pretty general thing to convict colored men in that precinct just before an election. They had more cases about election time than at any other time. So this was celebrated as another way around that 14th Amendment, a way to avoid the 15th Amendment. We've just got to use this. And I want to be clear, this was not the main reason that people lost the right to vote in the 19th century South. Literacy tests, poll taxes, violence and intimidation more generally did the bulk of the work of disfranchisement in the South. But these laws were things they kind of kept in their back pocket and brought out when there was a close election, brought out when the literacy test wasn't working, brought out in certain situations when they thought they needed them. One of the things that's challenging, and I think many historians are not completely successful at, is connecting regional histories to national histories. And if I'm looking at my book and I'm grading my research, I kind of give myself a B here. I don't think I hit it out of the park, but I tried very carefully to write about how what happens in the South affects the whole country. It's not a perfect job, but it's a solid job. So what I argue is that this becomes the norm nationwide in the late 19th century. It kind of hatches and is nurtured in the South, this idea that states should do this. But it does spread around the country for various reasons. And one of the reasons is the 13th Amendment. And hopefully some of you are familiar with the 13th Amendment, which reads, "Neither slavery nor involuntary servitude, except as punishment for a crime, whereof the parties shall have been duly convicted." So the 13th Amendment, many people say that the 13th Amendment ends slavery. What I say it does is it separates enslaved people that are enslaved by race with people that are enslaved for criminal conviction. In other words, under the 13th Amendment, involuntary servitude is okay if you've been if it's as punishment for a crime. And that kind of sets the stage intellectually for keeping felons disfranchised. It says if you've been punished for a crime, if you've been turned into a slave legally, then you can still occupy the legal status of a slave afterwards by being denied the vote. Another tradition or practice that is established in the South but also contributes to the spread of felon disfranchisement is the system of convict labor. What's going on here, and again, I'm painting kind of in broad strokes here. This is not the most precise part of my argument. But I argue that in the South, the idea that prisoners are essentially enslaved becomes part of like the popular visual culture and part of people's experiences. When people, instead of holding people in prisons, especially African Americans in prisons in the 19th century South, they put them out to work. They had them work on the streets, clearing brush, clearing swamps, doing whatever. And that this, again, what we're doing here is we're putting prisoners into slavery. We're making prisoners and slaves seem like the same kind of category, which again helps justify both legally as well as culturally the continued disfranchisement of people with criminal convictions. In addition, nationally, including in the South, we begin as a nation to abandon the ideal of reform and rehabilitation. In other words, we see prisons as places to punish people rather than places to fix people or change people. So if you see prison as a punishment, then there's no reason why you should be allowed to vote afterwards. If you see prison as an opportunity to be reformed, then it would make sense to let them vote afterwards, right? So as a country, if we move away from this idea of rehabilitation, it makes sense to have a nationwide tradition of disfranchising for crime. Which brings us to really the 20th century of felon disfranchisement, a nationalization of the Southern idea that incarcerated individuals are a degraded other, undeserving of rights, including the right to vote. And my sort of central argument is that race and slavery lay the groundwork for the socio-legal understanding of incarceration and thus the voting rights of ex-felons. All right, so the last 10 minutes or so, I want to talk about felon voting rights in the U.S. today before we open it up for questions and discussion. So we've got the past, we've got the present, now let's talk about the future. So there are reasons to be optimistic about criminal justice reform broadly in the United States today. First of all, incarceration rates are dropping. If you remember that graph I showed you a little while ago, you saw that in 2017 things are starting to tick down, and they're still ticking down a little bit. Incarceration rates are still very high, but they are on the decline. This is due in part, although not in total, to marijuana decriminalization, which means that incarceration rates may drop even more. So we may have fewer people locked up, which will mean fewer people losing the right to vote due to present incarceration or prior incarceration. There's also some bipartisan support for decreasing incarceration, including the First Step Act, which was signed into law by President Trump last year, which reduces sentences for certain federal crimes and tries to decrease incarceration at the federal level. So in some ways, the kind of fever that I would describe of the late 20th and early 21st century with regard to mass incarceration is kind of breaking. Across the country, I think there's a little bit of a growing idea that locking everybody up forever might not make sense for a bunch of reasons. That went the wrong direction. This is awfully texty as well, but I wanted to give you just a little sense. Many states are changing their laws. Many states are expanding voting access for ex-felons. And what I put on this list here, this is just in the last 2 years. So you can see here that this is just a bunch of examples. Colorado recently restored voting rights to people on parole. Florida just had this big constitutional amendment I'll talk about in a second. Louisiana just basically said that if you've been on probation or parole for 5 years, you can start voting again. Nebraska, probation and parole. Nevada also. New York just gave rights to people on parole. Wyoming removed the application process and automatically just restored voting rights for first-time offenders. So state after state is making it a little better. And like this goes on. If I go on and on for 2016 and 2015, many states are improving access to voting for people with prior convictions. Florida Amendment 4 is the big national story over the past 12 months. In 2018, Florida voters voted on a constitutional amendment which gave the right to vote back to people once they're released from prison. It changed the Constitution in Florida. It got 67% of the vote. So 67% of the people in Florida said, yeah, once you're out of prison, you should start voting again. Welcome back. What's happened since then is that the Florida legislature has passed a bunch of things to make it harder. They're saying you have to have paid all your fines, fees, and restitutions. They call those legal financial obligations. And if you haven't paid back your fines, fees, and restitution, and you try to register to vote, that's a felony. The problem with that is many courts don't even know how many fines people owe. So if you go to your court and say, hey, do I owe fines and fees still? And they're like, I don't know, when did you convict your crime? And you're like, oh, 20 years ago? And they're like, we don't really have records of that. So there's a very, very difficult record-keeping component to this. And there's a real fear that if we hold people accountable for paying everything back in Florida, and we don't know what people owe, then people could be accidentally committing felonies by voting without even knowing it. So this is actually a news story from Friday that came out. A judge ruled in a case on Friday that we can't do this. We have to follow the spirit of the vote. The people of Florida said, once you're not incarcerated, you should get to vote. And the legislature shouldn't be messing around with all these complicated tools to make it harder for people to vote again. So if you're watching the news in the coming months and even years, see what happens in Florida and see if the intent of the vote is truly upheld or if the legislature is able to weaken it. Virginia, there's a ton of examples here, but just a couple more. The governor of Virginia recently signed restorations of citizenship for a couple, I think it's 100,000 or so people. The governor in Virginia, the governor has to pardon you in order for you to get your rights back. Like, even when you're out of prison, he or she has to sign an executive order. And the governor of Virginia is like, fine, let's just start signing them. And he spent a month. He had to do like 100 a day for a month or whatever it was. But he pardoned a ton of people to give them their citizenship rights back. Alabama just recently changed their law. Alabama had a weird law where they said you couldn't vote if you were convicted of a crime of moral turpitude, but they didn't define moral turpitude. So you could go down to your election office and say, hey, can I vote? And they're like, well, is that moral turpitude or not? And you're like, I don't know. Every county defined it differently, and then the state attorney general had its own definition. So finally in 2017, they at least defined it so you knew whether or not you could register. And that's actually helped people in Alabama. Now that the law in Alabama is clear, people can start following it. That's all we ask, right? It's not clear in Tennessee. Many other states may follow soon. Arizona has a bill right now for automatic restoration. There's a campaign in Wisconsin to restore people who are on probation and parole. This is Georgia. There's actually a resolution in the Georgia Senate, so on and so forth. Okay, so that's your optimistic, happy part of my talk. Reasons to be pessimistic about voting rights generally. When I started this project, I began research on this project in 2007. And when I started working on this, the main reason that people lost their right to vote, if they were an adult and a U.S. citizen, was because of a prior felony conviction. In other words, felon disfranchisement in 2007 was the biggest obstacle to electoral participation for people that would otherwise be eligible. That's not true anymore. Today, we've entered a period that I call mass disfranchisement, in which voter ID laws that are increasingly complicated, requirements that you prove citizenship with your ID, birth certificate requirements, and so on, mean that people lose the right to vote for all kinds of reasons that have to do with their access to paperwork, their access to identification, and things like that, and also intimidation that comes from those laws. In addition, there's issues now with, or discussions that are going on now about redistricting, so that, I don't know if you guys have dug into this at all, but so that areas that have low, basically the number of people that are citizens in a district count for their redistricting rather than just people in general. Long story, I can talk about it more if you want to. But there's more and more things that are eating away at the right to vote and the ability of people to express themselves at the ballot box. And felon disfranchisement is important, but I don't think it's the most important story right now. Tennessee, briefly, before we wrap up. Felon disfranchisement in Tennessee. What's the story locally? So y'all saw that we have some of the strictest laws here and one of the most insane restoration processes in existence. In 2019, I just pulled these off the state legislative website the other day, there were a number of bills filed in Tennessee last year that would decrease access to the vote. So if you looked at what was filed and some of what was passed, there were a number of efforts in the Tennessee legislature to make voting even harder. The first one up there is the new law that criminalized some aspects of voter registration. That was actually passed. It's currently under litigation. Those are the two cases that are being litigated. About 3 weeks ago, a federal judge ordered a stay, like a temporary injunction, on enforcement of that law. So that's a moving target and a developing story here in Tennessee. There was another bill introduced by Senator Gresham in the Senate. I just put the Senate sponsors on here, who prohibits a person. This didn't pass, but this is a bill. Prohibits a person who is convicted of a felony under the election laws of the state and who is prohibited from voting, from entering the premises of any election commission or polling place during the time that ballots are being cast. So if you have a felony, you can't even go into the building on election day, or that's a crime if this had passed. We also have another piece of legislation from Gresham that says prohibits a person convicted of voter fraud from assisting a person with voting in the state. So, you were convicted of voter fraud, grandma can't find her glasses, and she's like, hey, which of these boxes should I check? That's not allowed. If you've been convicted of voter fraud, you can't assist a person with voting if that passes. It hasn't passed yet, but these are some of the things that are being introduced here in Tennessee. On the other side, there also is legislation being introduced here, also that hasn't passed, expanding access for ex-felons. Senator Gilmore, this would have just, I'm just going to read them, summarize them quickly. This would have basically the first one says if you're making payments, you don't have to pay off all your fines, fees, and restitutions, but as long as you're making payments, you can register. I thought that seemed like a good compromise to me. Akbari's legislation makes the paperwork easier, basically. Dickerson restores the voting rights of persons. Actually, Dickerson's legislation is in some ways the most radical here. He says that once you're out, even if you're on probation or parole, you could still vote. So there's some legislation to open up voting, and there's also legislation to close up voting around issues of felon disfranchisement. I noticed this just a couple weeks ago in the paper, though, whether the past repeats itself. There's a couple prosecutors, one in Knox County, I think one in Wilson County, although I couldn't find that article, that wants to start treating misdemeanor larceny, wants to start charging it as felony larceny in some cases. Knox County District Attorney began charging petty thieves who repeatedly strike Walmart and a handful of other major realtors, not as trespassers and shoplifters, the misdemeanor approach, but as burglars subject to increased fines and prison sentences. In other words, he's saying that if you commit multiple acts of misdemeanor larceny, they want to charge you as a felony, which this article didn't get it. This article was like, well, that would be sad because you go to prison for a long time, which it would be, but it would also be sad because you'd lose your voting rights. And it made me think of the 1870s in which people that committed minor larceny were losing their right to vote, and now we have some DAs here in the state that are saying, well, we're going to basically elevate minor larceny charges to felony charges that'll also bring about a loss of voting rights. So I'm interested in your thoughts, your questions, but these are a couple of the questions that I'm thinking about as I continue to work on these issues. Is felon disfranchisement just or unjust? Like, has what I just described to you a terrible story or a story of success? And there's obviously different opinions on this. Should incarcerated people be able to vote? A lot of people think that once you're out, you should get to vote. What about people that are still locked up? What are the ethics, the politics, logistical challenges of letting people in jail, and what would be the advantages of that. And finally, how does felon disfranchisement connect to other forms of disfranchisement, past and present? You guys have been talking about voting and the access to vote, and I'm curious about what your thoughts are about how the story that I've told you today is relevant to other stories of suffrage and access to voting. So, hit me with questions, comments, thoughts. Yes?
So in the graph you showed us at the beginning, there was a really steep skyrocket in like the 80s, 90s.
About,
About the number of people incarcerated. Yeah. Was that mainly when we started cracking down on like drug convictions, or were there other factors in play? What was the cause of that?
Great question. There are whole books written on the subject. There's a bunch of things happening. So we're talking here beginning with Nixon, President Nixon, and going through the Clinton administration. And I want to point that out because it's a bipartisan thing. Republicans and Democrats are both very much responsible. Whether you want to see that as a victory or failure is up to you, but everybody's doing this in that period. The stated reason they're saying is for public safety. A lot of it is about drug crime, but it's also just about increasing sentences. There's a sense back then that we need to have mandatory minimums, we need to have 3 strikes laws, and we have to have lock people up in order to prevent crime. A lot of the subtext is there about race. There is about race. In the 1968 election, on the 72 elections, Nixon plays a lot of like, we need more safety, but there's a lot of racial rhetoric in how he articulates needs for public safety. So yeah, those are many of the reasons. It's about drug crime, it's about the prevalence of drugs, but it's also a wider belief that locking people up is what we need to do in that time period. Good question. Other questions? Or thoughts? Yeah.
While other states in the South who in the past have had more difficult disfranchisement issues, and they're making changes, do you see Tennessee leaning more towards that?
That's a great question. You know, some days I wake up and I'm optimistic and some days I'm not. I'll give you an example. Louisiana is a very deep red state, right? Louisiana is almost elected a Republican supermajority, which Tennessee has. So very conservative, very Republican state. They just all got together, Republicans and Democrats in Louisiana, and they passed that 5-year law that says as long as you've been out of prison for 5 years, you can vote. So that gives me hope that there's a bipartisan desire for this, that Republicans and Democrats believe in forgiveness. They believe that voting is good for all of us, that having mass participation in elections is good for our society. So days like that, I feel optimistic that, 67% of the voters in Florida said, let's do this. Once you're out of prison, you should get to vote. So there are changes happening across the South. Tennessee seems in many ways more kind of intractable than other states. There's not a lot of, given the legislation to criminalize voter registration that came out of our legislature last year, there seems to be a pretty deep commitment in our legislature, from my perspective, to making voting harder. And until I see otherwise, that's kind of what I'm going with. I hope that in Tennessee, I personally believe everybody should get to vote. So it's my hope that Tennessee will follow the path of some other southern states. I haven't seen a lot of evidence yet that that's going to happen, but I could be wrong. I would love for, heck, if Dickerson's bill could pass this session, that would be amazing. Who else? I see people sort of doing things with their hands. Mary.
I just wanted to make the comment that several weeks ago when we had those legislators on our podium here, the one member of that group who is part in the State House Committee on Elections and Campaign Finance, so he's one of 5 members of that committee, said very blithely, in running through one of his statements, something about, oh yeah, and then if you're a felon, you can of course get your rights reinstated. And I just about had a coronary because I was thinking about Dr. Holloway, and I thought,
And all this, that whole
all
process.
of that, like, are you kidding me? I was hoping one of you, because I am sort of in a position where I can't ask those sorts of things, but I hoped one of you would just jump up and down and say, oh, can you tell us specifically how one does that, sir, in the state of Tennessee? So next time you have that opportunity, please don't miss it.
Other questions? Is that, yes?
So historically, Tennessee has been very moderate. We see that in the Civil War and all that stuff like that. From like a historical perspective, do you have any ideas as to like what exactly happened to Tennessee to make us such a deep state? And like make us against it?
Well, let me answer it first from the question of felon disfranchisement, which is kind of a funny thing. I think it's sort of accidental here in Tennessee. Tennessee's laws actually have been largely unchanged since the 1830s. So Tennessee's laws about felon voting, they're basically the way they were in the 1830s, which means to me it's not about race, right? Because only white people were voting in the 1830s. But what happens in Tennessee is those laws that I think were initially not really about race come to do work that's about partisanship and racial bias. And more generally kind of a popular idea. I think there's a sense in Tennessee, as there are in many states, that people that have committed crimes are kind of bad people and they should be punished, and that voting is a privilege and a reward, and you should lose that. I mean, that's the thing that reasonable people believe. I don't believe it, but reasonable people believe it. And it has more traction in Tennessee. So I would say in Tennessee, with regard to felon disfranchisement, I think the legal story is kind of an accidental one, but the cultural story is kind of a little more intentional. Like, come on, if Alabama is changing, if Mississippi is changing, it seems like we can change too. And I think your larger question about why Tennessee politics, I'm not a big expert on Tennessee politics specifically, but my general sense as a kind of historian and citizen is that Tennessee politics have gotten less moderate over the past couple decades for complicated reasons. I mean, we are one of the reddest red states, right? There's less bipartisanship here than even in places like Georgia, Kentucky, places like that. So we've gotten deeper redder for a lot of reasons as a state that we can talk more about later, but that's my sense of it. Yeah.
I'm curious, do you know in other developed countries if this whole thing happens, like how we can compare and contrast?
That's an awesome question. There's some really good articles on that, and people have been doing research on that. The very short answer is we're totally an outlier here. So for example, in the European Union, the EU Constitution, you vote in prison. Everybody in Europe votes, full stop, end of story. In most other countries, it's the same thing. Voting in prison in many places, almost no country that I can think of has anything like the system that many US states have, in which it follows you for the rest of your life after incarceration. That's just not a thing anywhere. Even more generally, most developed countries, democracies more broadly, if you look at election law across the world, almost every country in the world is trying to make voting easier. They want people to vote. Whether you're, having your ink stained in the South, your finger dipped in ink to prove you voted in South Africa, that's the only requirement. If you're, whatever it is, most countries, they have little mobile vans that go around poor neighborhoods and give out people free IDs so that they can vote. They've had people go door to door registering voters so that everybody can vote. Like most countries have huge efforts to get everybody to vote. And the laws are really pushing that. Whereas in the United States, it seems very much the opposite. Of course, there's exceptions, but as a worldwide trend, we're very different in making voting harder at this point. Other questions? Yeah.
So in the mid-1980s to the 1990s, there was a huge push in the court systems for challenges to felon disenfranchisement with the 14th Amendment and the Voting Rights Act. Did you see any kind of shifts in your research with state constitutions and statutes that kind of reflected that? Like, I know that Alabama Constitutional Convention was explicitly racist, but because they had updated their statute since, it wasn't a violation.
Exactly right. Very good. Yeah, you're totally right. So the short answer is no, because of a 1974 Supreme Court case called Richardson versus Ramirez, in which the U.S. Supreme Court read the 14th Amendment, Section 2, and interpreted it to mean that felons did not have a constitutional right to vote. And what they use that to say is that therefore the Voting Rights Act doesn't really apply to ex-felons. So there's a strict scrutiny of anything, whether under the Voting Rights Act or just the plain old Constitution. There's a very careful scrutiny of anything that limits people's rights to vote, or was. That doesn't apply to felons because under their interpretation of Section 2, felons do not have a constitutional right to vote. You can take a look at Section 2 and I'd be happy to talk with you more further about it. I actually, when I wrote this book, one of the reasons that I wrote this book was to try to prove that interpretation of Section 2 of the 14th Amendment was wrong. The Supreme Court in 1974 said the framers of the 14th Amendment did not want felons voting, and they intentionally wrote it that way. the language is a little obscure. I didn't really believe that interpretation. So I dug into all this stuff, and I was wrong. Like, I actually do think that they kind of meant that in the 14th Amendment, and they knew what they were doing a few years later. So I ended up kind of shooting myself in the foot in terms of my own political agenda by finding the history seems to support a political agenda that I don't personally support. In other words, my research kind of upholds the conclusions of Richardson versus Ramirez, alas. But you got to tell it as you see it. You had your hand up.
Yes, you mentioned how 2 states in the U.S. have the ability for people to vote while they're incarcerated, and you also mentioned that most countries in the EU also do that. Is there any data out about how having the right to vote in prison influences convicts when they're released?
There is a little bit of data. It's not great data, but I use it anyway. There is one study that says, there may be more since I haven't looked at it recently, but about 10 years ago a study came out that said people that vote, okay, not while in prison, people that vote after incarceration are less likely to reoffend. Which seems to be a great argument. If you believe that people should get the right to vote, then arguing that voting tends to have an impact on recidivism is a pretty powerful argument. It's not really clear the cause and effect lines up, though. It might just be that the people voting are the ones less likely to offend. But you're asking about people that are incarcerated voting.
As a way to kind of like reintroduce them.
Yeah, I haven't seen that. I don't read a ton on like European political science. It would be really interesting to see if anyone have dug into that. That would be a neat literature search to do. To try to sort of say, well, why does voting matter for incarcerated people? What impact does this have on, you could ask what impact it has, say, on prison discipline, what impact it has on recidivism, what it has really on anything. I would hope someone's looked at that, but I don't really know. Good question, great question. Yeah.
During one of my classes, a professor came and talked about research she had done of looking at women who are in prison in Georgia and who are affected by laws like the three-strike law, stuff like that, and who are unable to have their cases reviewed in order to be put on parole, stuff like that. How do you think that changing laws like that to help people get out of prison or not get put in prison in the first place will impact voter disenfranchisement?
Well, the sort of short answer is the fewer people we have incarcerated, the fewer people will lose their right to vote, right? I mean, I don't know if you're intentionally throwing me a softball question or not.
Do you think that there's a benefit in fighting laws like that would, in order to help them?
Yeah, I would think so. I mean, Georgia is actually a weird one. I was pulling numbers last night on numbers of people on probation and parole. Georgia is way higher than anybody else. 5,000 out of 100,000, like more than almost three times the next state. Like Georgia has a huge number of people on probation and parole. There's a little bit of legislation now to try to limit that. But I mean, yeah, I mean, for me, my kind of basic sense of this is that if you want people to act like members of society and not commit crimes, giving them the opportunities to participate in society makes them less alienated, right? And this is, funny enough, these are arguments people made. If you look at my book, they were making the same arguments in the 1830s. They were like, you know, if you release people from prison, you don't let them vote, well, they're not going to feel like they're part of society again, and they might offend, you know, it might increase recidivism. So people have been making those arguments about these laws since these laws began. But again, those are questions that possibly could be tested through research. It'd be interesting to do. You had your hand up.
What personally got you interested in this topic?
I was registering voters in public housing projects in 2006 and 7. And I had the Tennessee form with all these stupid things on it. And people kept asking me questions. They're like, well, can I vote? And I'm like, I don't know. Were you convicted of voter fraud after 2006? Or was it murder before 1990? And I was like, oh my God. So I went to the library because I'm such a dork. I went and read the law, right? Because I wanted to tell people the right thing. And I got to the law and I saw all this and I'm like, this is crazy. And when you're a historian and you see a really complicated law, you know there's a story there, right? And you can just look at this and you're like, something happened to make this the law, right? So it made me want to dig into the history of it. I thought I was going to research the 20th century, but what I discovered was the really interesting story from my perspective was the 19th century. So actually, you know, there's still a lot of work to be done. If any of you are aspiring historians or political scientists or sociologists, these are laws that have not been very well studied. Really in any of these disciplines. And a lot of these questions you're asking me, There's some literature on this, but not a ton. And certainly state-level stories can be told and need to be told. So keep digging. Other questions? Up, in the back.
You said that, like, you showed us how in Florida, like, the general population voted, and 67% of them said, oh, after you get out, totally, you can vote. That's
Yep.
totally cool. Then why was the Florida legislature's response to that to make it harder? If they saw that 67% of the general population thought it was cool.
So the Florida legislature is dominated by Republicans who feared that these laws would increase the number of African Americans that can vote, because African Americans were disproportionately, in Florida, 25% of African Americans can't vote because of these laws. So a lot of those legislators feared that either in their district or in statewide races, these laws could have a big impact. Changing this law, the amendment could, if the amendment was enforced as it appears that voters intended it to be enforced, it would have a big impact on Florida elections. So I see that as completely a partisan battle. And I don't like to make kind of judgments like that. Like, I like to hope like their hearts are pure and true. But I think it's pretty clear in Florida that what you're pointing out is a pretty stark contrast between what the voters of Florida wanted and what the legislature is kind of doing behind people's backs. They're gerrymandered, so they're often very safe seats. I don't think anybody's going to say, well, I'm not voting for that guy because he tried to undermine Amendment 4. You know, I'm going to become a Democrat because my legislator tried to undermine Amendment 4. I think they're figuring that it's not going to destroy their careers to go against the electoral majority there. Yeah.
I had a question about, has the felony voter disenfranchisement kind of deal affected the queer populace in a sense, especially just like prior, I think it was the 60s or something, it was a felony, sodomy was a felony in every state, and they used that as one of those. Has that actively affected their rights to vote, especially in more modern times?
This is a great question that I would certainly be interested in. I would say what you'd have to figure out is if LGBTQ people are more likely to have criminal convictions, which could help you surmise whether they're more likely to be impacted by these laws. And I don't know the answer to that. I mean, you're right, definitely for the pre-Lawrence v. Texas era, these laws are on the books. They were enforced sometime, not very often after the 60s. I don't know. That would be a neat thing to research. But beyond that, I can't. Yeah, I don't know. I mean, maybe might they be statistically more likely to be on probation and parole? I don't know, because of economic disparities or because of probation or parole boards that are homophobic. So there may be data that says if you're LGBT, you're more likely to have a longer parole sentence than not, probation. I don't know. Good questions. Other questions I can't answer. Hit me.
Tell me your experience when writing your book. Did you feel obligated to write your book? Was it something you wanted to do?
So yeah, I mean, I felt some pressure to get the thing out because of the upcoming elections. I'd hoped to have it out before the 2012 election, but I didn't, because I was hoping that I could be part of kind of national discussions about this. In terms of my own personal, I love to write. I love to do research. I mean, teaching's lovely, but I'm pretty happy writing and researching. So my personal experience was that it was quite lovely. One of the cooler things, though, is the fellowship I got from George Soros and the Open Society Foundation, because it meant that, sometimes when you're writing, you're it's like me and my cat in front of the computer all day, and it's a little lonely. But because of the OSF, I would go to these meetings of other people that were working on these issues, and I became part of a nationwide network of people that are some amazing people. I'm by far the most boring person in the room there. Some of these people, they've been on death row for 20 years. They are, people like the guy that edited the Angola prison newsletter. The people that are in this group of fellows are just incredible. So really one of the biggest privileges was for me to get to interact with other people that are working on current criminal justice issues, stuff that'll blow your mind. And being able to be in the room with them and being I'm working on this stuff too, that was really fun. And now, it's funny, one more thing about the book. The book came out in 2013. I got some headlines, I got some reviews, it was all right. But it's really been in the last 2 or 3 years that it's kind of gotten traction. I don't know if that's because of our current politics or what, But I am speaking all the time now. Like, I've given 5 talks this semester. You just got back from Baton Rouge. I'm leaving for Baton Rouge on Wednesday. I spoke at Vanderbilt last week. I was in Oak Ridge the week before. I was in New York. I mean, like, people want to hear this stuff now. So for whatever reason, my experience writing the book was a little disappointing when it first came out. And now I'm like completely overwhelmed by how much people are interested in it, which is great though. Yeah.
Will you ever like rewrite the book and add new information in it?
I'm kind of moving on personally. Like, I'm glad to keep doing the talks, but I've got this project that she mentioned earlier on the right to be a witness that I'm really interested in. And right now, like, that's what I want to work on. So I'm glad people are interested in this, but I got bigger, not bigger, but I'm like, intellectually, I want to dig into new stuff. So good question, huh?
All right, let's thank our speaker.